Donald Trump has just threatened legal action against Trevor Noah, not over an investigative report, not over a political analysis, over a joke, a 30-second moment at the Grammy Awards connected to Jeffrey Epstein's island. And there is something critical that most people are missing about this situation. This is not about defending a reputation. This is about using defamation law as a tool to suppress speech. And if you look at this through the lens of someone who understands how legal proceedings actually work, Trump has just created a situation that could expose far more than he intended. Pay close attention to what comes next. Sunday evening, February 1st, 2026. The Grammy Awards ceremony. Trevor Noah is hosting for the fifth and final time in his career. Billie Eilish takes home Song of the Year for Wildflower. Noah steps up to the microphone and delivers a line. That is a Grammy every single artist wants almost as badly as Trump wants Greenland, which actually makes a lot of sense because Epstein's island no longer exists. He is going to need a new one to spend time with Bill Clinton. The room erupts in laughter. Noah lets the moment sit, then adds, "I already told you, this is my final year. There is nothing anyone can do about it." By 10:01 the next morning, Trump is on Truth Social. And this is not a casual one-liner. This is a prepared, detailed statement of roughly 300 words. The important sections need to be examined closely. Trump wrote that Noah had made an incorrect claim, specifically that Donald Trump and Bill Clinton had been on Epstein's island together. Trump stated clearly that he had never set foot on Epstein's island and had never been anywhere near it. He added that until Noah made this statement, no one, not even what he called the fake news media, had ever accused him of being there. And then came the threat. Trump called Noah a total loser. He promised that his legal team would be reaching out. He told Noah to look at what happened to George Stephanopoulos. He told him to look at what happened to CBS. And he ended with a line that made the intention unmistakable. "Get ready, Noah. I'm going to have some fun with you." Trump was referencing real events. ABC News settled with Trump for $15 million after Stephanopoulos stated on air that Trump had been found liable for rape. The actual legal determination was sexual abuse. CBS settled for $16 million over the way a 60 Minutes interview with Kamala Harris had been edited. So Trump is coming off two significant financial victories. He feels like the system is working in his favor. But here is where the situation turns against him. What Noah delivered that night was not a factual claim presented as news. It was a joke. It was performed by a comedian at an entertainment event in front of an audience of millions who clearly received it as humor, and satire directed at public figures carries a very different set of legal protections than reporting or factual commentary. But there is another element here, one that Trump's own legal advisors should have flagged long before he posted that statement. 3 days before the Grammy Awards, on January 30th, Trump's own Department of Justice released more than 3 million pages of documents connected to the Jeffrey Epstein investigation. Deputy Attorney General Todd Blanche appeared at a podium and informed the public that the release satisfied the requirements of the Epstein Files Transparency Act. So what is actually contained in those documents? Trump's name is referenced more than 3,000 times across the files. That number is significant, and it is worth sitting with for a moment. The documents contain emails in which Epstein and people in his circle exchanged articles written about Trump. They contain photographs of Trump present at properties owned by Epstein. They include an internal communication from the Southern District of New York that states Trump traveled aboard Epstein's private aircraft on considerably more occasions than had ever been publicly acknowledged or reported. They contain statements from individuals connected to Epstein's network, including accounts from one of Epstein's victims describing how Ghislaine Maxwell indicated she was making herself available to Trump and his associates. The records note that nothing physical occurred, but the nature of Maxwell's statements suggested a standing arrangement. The files also include a deposition from a staff member at Mar-a-Lago who described the social relationship between Trump and Epstein, noting that while the two spent time together with regularity, Trump preferred to eat in a separate area of the property rather than at the main table. Trump has consistently and firmly denied any wrongdoing. He has never faced criminal charges in connection with Epstein. Bill Clinton is in the same position. Both men have stated that they had no awareness of Epstein's criminal conduct. But here is the question that any competent prosecutor would ask immediately. If you are preparing to bring a defamation suit against someone because they made a joke linking you to Epstein's island, are you genuinely prepared to open the door to a formal legal examination of your entire relationship with Jeffrey Epstein? Because filing that lawsuit is exactly what would trigger that examination. Noah cracked a joke. Trump's answer was that his lawyers would be in touch, but before examining why this lawsuit is almost certainly going to fail, it is necessary to understand what Trump is actually trying to accomplish. And winning in a courtroom is not the objective. Here is what is not being discussed openly about the way Trump uses litigation. Trump does not file lawsuits because he expects to prevail at trial. He files them because the act of filing changes the environment. It creates pressure, it shifts the dynamic. From a prosecutorial standpoint, the pattern is clear. Over the course of his career, Trump has initiated a large number of defamation cases against various targets. He has settled some of them, he has lost others. But the final result in any given case has never been the real point. The point has always been the existence of the threat itself. When Trump pursued legal action against ABC and CBS, he was going after organizations with substantial legal budgets and experienced attorneys. Both networks had credible First Amendment arguments available to them. Both could have mounted a serious defense. Instead, both chose to settle. ABC handed over $15 million. CBS handed over $16 million. Together that is $31 million paid out over statements that were either accurate or substantially close to accurate, with only minor technical distinctions at issue. Neither network admitted to being wrong. They made a practical decision. The cost of a prolonged legal battle outweighed the cost of ending it quietly. Now Trump is bringing that same approach to a comedian. But the situation is fundamentally different this time. Noah was not making a factual claim. He was delivering a joke. And under the framework of First Amendment law that was established by the Supreme Court in Hustler magazine versus Falwell in 1988, satire and parody about public figures receive the widest possible legal protection available. To succeed in a defamation action, Trump would need to establish 4 separate elements. He would need to show that Noah made a statement that was false, that the statement was directed at Trump specifically, that it was communicated to an audience, and that it resulted in concrete damage to Trump's standing. But Trump is not an ordinary private citizen. He holds the office of President of the United States. That designation places him squarely in the category of a public official under the legal standard set by the Supreme Court in New York, Times versus Sullivan in 1964. Under that standard, Trump carries the burden of proving what the law calls actual malice. That term does not mean spite or ill intent in the colloquial sense. It is a precise legal concept. Actual malice requires proof that the person who made the statement either understood it to be false when they said it, or demonstrated a reckless indifference to whether or not it was true. And this is the fundamental obstacle in front of Trump. It is not possible to establish actual malice over a statement that was delivered as obvious comedy. In Hustler versus Falwell, the Supreme Court confronted this exact tension. Hustler had published a deliberately outrageous parody depicting Jerry Falwell, a well-known televangelist, in a deeply offensive fictional scenario. Falwell pursued claims of both defamation and emotional harm. The court ruled without a single dissent that parody, regardless of how extreme or offensive it might be, cannot meet the threshold for defamation if no person acting reasonably would have understood it as a genuine factual claim. Chief Justice Rehnquist wrote that the kind of open political exchange the First Amendment is meant to defend will inevitably generate speech that challenges and criticises those who hold positions of authority. The court went further, stating that if parody were not protected, political satirists and cartoonists would face financial liability simply for doing what they have always done, without any requirement that their work contained a genuinely false statement about its subject. Apply that reasoning directly to what happened at the Grammys. Was there a single viewer in that audience who walked away believing that Trevor Noah had just presented verified reporting on Trump's activities? Or was every person in that room watching a comedian deliver a well-crafted joke during an awards broadcast? The laughter itself serves as evidence. The collective reaction of the audience demonstrated a shared understanding that this was performance, not journalism. But the legal weakness of Trump's position is only part of the problem. There is a strategic dimension that is arguably more damaging. If Trump moves forward with this suit, he initiates a process called discovery. Discovery is the pre-trial mechanism through which both sides in a lawsuit gain the ability to demand the production of documents, conduct depositions, and compile evidence. Courts enforce these requests. The material must be provided, and the scope of what can be requested is tied directly to the subject matter of the case. If the case is about a joke connected to Epstein's island, then Trump's relationship with Epstein becomes the central subject. Noah's attorneys would have the standing to demand every piece of communication that passed between Trump and Epstein. Every email, every phone record, every text, every travel document. They could compel Trump to sit down and answer questions under oath regarding the full history of that relationship. When did it begin? How frequently did they interact? Which properties did Trump visit? What did Trump know about Epstein's conduct, and at what point? They could subpoena employees at Mar-a-Lago. They could bring in anyone who observed the two men together. They could take the documents the Department of Justice released on January 30th and put specific questions about those documents directly to Trump on the record. No attorney advising a client in Trump's position would recommend taking that risk. The potential consequences of that discovery process are far more significant than any outcome the defamation case itself could produce. But Trump is not reasoning like an attorney evaluating legal exposure. He's reasoning like a political figure who has learned to use the courts as an instrument of control. Now consider the timeline in its full context. January 30th, the Department of Justice publishes the Epstein documents. Almost immediately, lawmakers begin to challenge the completeness of the release. Representative Ro Khanna, one of the legislators who helped draft the Transparency Act, pointed out that the DOJ had flagged over 6 million pages as potentially relevant, but was making available only around 3.5 million. Representative Robert Garcia, the ranking member on the House Oversight Committee, stated directly that the administration appeared to be deliberately holding back roughly half of the material while claiming to have fulfilled its legal obligations. Trump was, at that moment, facing growing political pressure over the Epstein files. The narrative was moving toward the possibility of a deliberate cover-up. Congressional Democrats were calling for the release of the remaining documents, and then, 72 hours later, a comedian jokes about Trump and Epstein's island on live national television. Trump responds not with a shrug, not with a light-hearted dismissal, but with a formal threat of legal action. From a strategic standpoint, this is a recognizable move. Rather than continuing to answer difficult questions about the completeness of the file release, Trump redirects. He shifts into the role of someone who has been wronged. He frames Noah's joke as proof of unfair and baseless attacks. The conversation stops being about what the files contained and starts being about whether Noah had the right to say what he said. But the specific claims Trump made in that Truth Social post do not withstand scrutiny. He asserted that Noah accused him of having been on Epstein's island, and that no one had ever made that accusation before. Neither statement is accurate. Noah's joke did not allege that Trump visited the island. The structure of the humour connected Trump's interest in acquiring Greenland to the disappearance of Epstein's island. It was a satirical juxtaposition, not a factual allegation. And the Epstein files, released just days earlier, had already placed Trump at multiple Epstein properties, documented his travel on Epstein's aircraft, and connected him to Epstein in over 3,000 separate references within federal records. If this dispute ever reaches a courtroom, those facts become central to the proceedings. The defense does not need to argue that Noah told the truth, because Noah was not making a truth claim. He was performing satire. But if discovery opens, the factual record regarding Trump and Epstein becomes available to both sides. And in defamation proceedings, the truth of the underlying facts is an absolute shield against liability. What is taking place here extends well beyond one comedian and one president. This is part of a broader and deliberate effort to deploy defamation law as a mechanism for controlling public discourse, and it is producing results, not because Trump is winning these cases on the merits, but because the threat of litigation is sufficient to alter how people behave. Consider the decision process for any journalist or public commentator. The information may be verified, the reporting may be airtight. The legal basis for a defamation claim may be essentially non-existent, but the prospect of years of court proceedings, of mounting legal fees that can reach into the millions, of becoming the focus of a public and politically charged battle, that prospect is enough to make many people reconsider. They adjust their language, they steer away from certain subjects, they pull back from investigations that might attract attention from a litigious public figure. ABC did not settle because its reporting was wrong. CBS did not settle because its broadcast was inaccurate. Both organizations settled because the practical cost of defending their position exceeded the practical cost of resolving it. The Supreme Court addressed this precise dynamic in Sullivan. Justice William Brennan wrote that the First Amendment demands protection for speech that is forceful, critical, and at times deliberately uncomfortable when directed at public officials. He acknowledged that this standard would occasionally shield statements that turned out to be inaccurate, but he argued that the alternative, a legal climate in which critics of powerful figures lived under constant threat of financial ruin, would ultimately destroy the capacity for open democratic debate. Trump's approach to litigation is designed to exploit precisely the gap between the legal rights that exist on paper and the practical realities that shape behavior in the real world. Noah would in all likelihood prevail if this case went to trial, but the act of litigating becomes a form of punishment in itself, and that is the true objective. There is one additional consequence that deserves attention. Trump's pattern of litigation threats does not succeed in burying the stories he wants buried. It amplifies them. The settlement with ABC drew public attention back to the E. Jean Carroll case and the findings that emerged from it. The settlement with CBS raised questions about editorial practices that had not previously been widely examined. And this threat against Noah has triggered an immediate and widespread surge in public interest in the Epstein files. Millions of people searched for information about Trump's documented connections to Epstein within hours of the Truth Social post going live. The legal threat did not suppress the story, it became the story. The integrity of the legal system rests on the principle that it applies equally, that no individual, regardless of wealth or position, can weaponize it against others without consequence. That principle requires journalists to be able to report without fear of financial retaliation. It requires comedians to be able to satirize without being dragged into courts. It requires ordinary citizens to be able to criticize the people who govern them. Trump's use of defamation law as a silencing tool does not threaten these principles because his cases have legal merit. They threaten them because the process itself creates a chilling effect that operates independent of any verdict. Watch what develops from here, whether Trump follows through and files, whether Noah and CBS mount a defense or seek to avoid a prolonged battle, whether this becomes a moment where the courts reaffirm the protections that Hustler versus Foal established decades ago. The outcome of this situation matters, not only for the people directly involved, but for anyone who believes that accountability, transparency, and the freedom to speak truth to power are essential to how a democracy functions. Stay informed. The details of what happens next will be significant.